everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty here at iExamB. Today I'm starting with a new series for all those who are preparing for SEBI Grade A Legal Officer examination, and this series is exclusively for Phase 1. I will be covering all the important concepts of Phase 1 examination for the law paper in this particular video series. This is the first video, and don't forget to subscribe to LegalBee and stay tuned for all the upcoming videos from this series, as this is going to be a conceptual video series and this will definitely help you out in clearing your concepts, and also you will understand that which all topics are very important from exam point of view. क्योंकि syllabus तो आपके पास होता ही है, but आपको doubt ये होता है कि क्या पढ़े क्या नहीं पढ़े, but जो बहुत ही ज़्यादा important है वो सारे कंसेप्ट्स एक क्रक्स में आपको एक कंसेप्ट का एक वीडियो में देना चाहूँगी. सो डोंट फॉरगेट टू सब्सक्राइब, एंड इफ यू हैव एनी क्वेरीज और यू रिक्वायर एनी video on any particular concept, you can directly write to us in the comment section of this video. You can also email us on hello@iexambi.com, or you can call on this number 9205524028 that is visible on the screen. Visit our website www.iexambi.com for details of all the courses, online courses available at iExamB. So the series that I'm starting is named as Phase 1 Made Easy, Learn with Amrita Mam, as I will be dealing with all the important concepts which I already told you for SEBI Grade A Legal Officer Examination Phase 1. Phase 1 को सिंप्लीफाई करने का ये सबसे बेस्ट तरीका होगा अगर आप इस वीडियो सीरीज को फॉलो करते हैं वन बाय वन. सो आई वुड टेल यू दैट आप सारे वीडियोस को स्टेप बाय स्टेप देखिए, एंड ये सिर्फ एक पर्टिकुलर सब्जेक्ट या दो सब्जेक्ट नहीं, मैं सारे सब्जेक्ट से कवर करने का ट्राई करूँगी. सो स्टे अपडेटेड फॉर दैट एज वेल. So the topic that we are going to discuss in this video series first is arbitration agreement. I will be telling you that why I am dealing with this topic also, and also will be telling you some basic details about arbitration agreement and also Arbitration and Conciliation Act. फर्स्ट लेट अस अंडरस्टैंड दैट जब हम कोई भी कंसेप्ट पढ़ना स्टार्ट करते हैं या कोई भी एक्ट पढ़ना स्टार्ट करते हैं, फर्स्ट वी शुड नो द बैकग्राउंड हिस्ट्री ऑफ दैट, देन ओनली वी कैन लिंक आवरसेल्व्स टू द बेसिक कंसेप्ट ऑफ दैट पर्टिकुलर एक्ट. So Arbitration and Conciliation Act that we are going to particularly study, and the concept from that act we are going to study in this video today, is linked to what? It is linked to the concept of alternate dispute resolution. What is the meaning of alternate dispute resolution? It means that you are going to settle your disputes by an alternative mode when you are going to settle your disputes outside court. सो ये आर्बिट्रेशन और कंसीलिएशन एक्ट 1996 जो है, जो कि आपके सिलेबस में है, वो डिस्कस करता है दो मोड्स के बारे में. एडीआर काफ़ी सारे मोड्स के बारे में बात करता है. इन दैट वी आर गोइंग टू कवर दिस एक्ट in our syllabus for phase 1. In that we have two modes, that is arbitration and conciliation. Arbitration की अगर बात करें तो वो काफ़ी important concept है and simple भी है. Just you should understand first that how arbitration is different from normal court procedures. In normal court procedures, court will adjudicate the matter by the proper procedural laws and everything, evidence हो या जो भी laws है. लेकिन arbitration में ऐसा नहीं होता. arbitration में there is flexibility, there is saving of time, and सबसे main difference ये होगा that in case of arbitration, even the arbitrator who is going to adjudicate the matter, who is going to decide the matter for the parties, will be of the choice of the parties. जैसा court में नहीं होता है. In courts, the judge is not of your choice. So all these things are voluntary. So the voluntary thing is, or the voluntary element is very very important in case of ADR, and especially in case of arbitration agreement. तो उसी से निकल के आता है कंसेप्ट आर्बिट्रेशन अग्रीमेंट का, एंड दैट्स वाई इट्स अ वेरी वेरी इंपॉर्टेंट कंसेप्ट. आई होप आपको समझ में आ गया होगा कि इसका लिंक कैसे है और ये कंसेप्ट इतना इम्पॉर्टेंट क्यों है जो मैं इसको पहले डिस्कस कर रही हूँ आर्बिट्रेशन एंड कंसीलिएशन एक्ट से. बिकॉज द वॉलेंटरी एलिमेंट इज प्रूव्ड बाय वे ऑफ एन आर्बिट्रेशन अग्रीमेंट. इट टेल्स दैट द पार्टीज आर रेडी फॉर एन आर्बिट्रेशन, एंड दैट टू इन राइटिंग. So let us see the relevant provision also for that, because the provision is very important. So हम इसे step by step पढ़ेंगे, and I would suggest कि आप इसका section number भी याद करने का try करें. वैसे सेक्शन नंबर से भले ही क्वेश्चंस नहीं पूछे जाते हैं, बट as the pattern is changing and everything is like modifying in the examination, so we should be prepared at least with the landmark sections. Section 7 arbitration agreement से deal करता है. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise. Means the disputes have already arisen or which may arise, यानी कि future disputes की भी बात होती है arbitration agreement. Arbitration agreement एक prior date पर हो सकता है. In respect of a defined legal relationship, whether it is contractual or not. This is very very important point कि वो defined legal relationship तो होना चाहिए, भले ही contractual हो या ना हो. I hope ये अभी आपको clear हो गया होगा. Now जहाँ से questions आ सकते हैं, MCQ बेस्ड एग्जामिनेशन में हमें कुछ सेक्शंस का बहुत ध्यान देना होता है, जहाँ से हमें पढ़कर ही एक ग्लांस में समझ में आ जाता है कि दिस कैन बी फ्रेम्ड एज अ क्वेश्चन इन एन MCQ पेपर. So we should be very careful about such points in the sections and the provisions that we come across. So arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. यानी कि separate agreement है तो well and good, लेकिन अगर आर्बिट्रेशन अग्रीमेंट सिर्फ एक क्लॉज के फॉर्म में है, जो कि जनरली बहुत कॉमन फॉर्म है, देन इट कैन बी एन आर्बिट्रेशन clause also in a contract and it can be recognized as a valid arbitration agreement. Clause number 2 of section 7 talks about it. Section 7 clause 3 is also very important. It talks about an arbitration agreement shall be in writing. यानी कि कोई choice नहीं है, it is a compulsion that it is going to be in writing. An arbitration agreement is in writing if it is contained in a document signed by the parties. ये तो obvious है, parties का signature तो होना ही चाहिए because voluntary process है. An exchange of letters, telex, telegrams are the means of telecommunication. I would draw your attention to this term telecommunication because electronic means have also been included over here by ways of an amendment. यानी कि अगर आपको कोई twist करके question दिया जाता है, suppose कि communication through WhatsApp है, तो क्या ये arbitration agreement valid होगा? Whether it will be recognized, ऐसा twist करके भी अगर question आ जाता है तो try to brainstorm yourself now itself that you are prepared with your answer in your mind crystal clear. यानी कि ये किसी भी फॉर्म में अगर कम्युनिकेशन होता है और वो रिकॉर्ड पर है, भले ही वो इलेक्ट्रॉनिक रिकॉर्ड क्यों ना हो, then it is a valid arbitration agreement as per section 7. An exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other means that can also amount to a valid arbitration agreement. Why this definition is so broad for arbitration agreement? Because court wants to promote ADRs, dispute settlement mechanisms. इससे कोर्ट के disputes की pendency भी खत्म होगी, कम होगी, खत्म नहीं तो कम तो होगी एटलीस्ट. एंड इट्स अ वॉलंटरी प्रोसेस. अगर पार्टीज खुद से आना चाहते हैं तो हम उनके किसी भी फॉर्म में हो वो अग्रीमेंट, उसको हम लोग किसी ना किसी वे में अकोमोडेट करना चाहेंगे इन द फॉर्म ऑफ एन आर्बिट्रेशन अग्रीमेंट. दिस विल बी आवर अप्रोच. सो ऑल दीज थिंग्स आर अ पार्ट ऑफ इंटरप्रिटेशन एक्चुअली. The last clause, which is also a very important one, the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is to make that arbitration clause a part of the contract. यानी कि reference से कोई भी reference नहीं होना चाहिए. It should be a substantial one that it is pointing out towards making that arbitration clause a part of the contract. So all these things make around 3 to 4 questions very क्रिस्टल क्लियर. अगर हम सोचे तो आर्बिट्रेशन अग्रीमेंट से अगर कोई भी क्वेश्चन आता है आपको तो अब वो आप बिल्कुल सही करके जाएंगे. दिस आई कैन इंश्योर यू and that is why I have come up with this series. Arbitration agreement I would say is a very very important topic and इससे आपके काफ़ी सारे concepts clear हो जाते हैं, at least nature of arbitration के बारे में. I think so. So this is what I had to discuss with you all about arbitration agreement. Do focus on such kind of pinpoint. I will try to point all these important concepts from phase 1 point of view definitely in this video series. And if you also have any queries, do reach out to us, because all these rooted concepts in these laws, such rooted concepts and principles will definitely make your preparation very nice and it will make your phase 1 preparation quite easier. So all the best for your preparation. Don't forget to subscribe to Legal Bee and prepare 50% faster with iExam Bee. Thank you, everybody. Have a good